Good morning. I apologize for my voice this morning. Can you hear me? Welcome to the Panel B open session for the Medical Board of California. My name is Richard Thorpe. I'm the chair of the panel, and I'll ask to have the roll called, and we'll begin proceedings.
Dr. Fielder?
Here.
Ms. Lawson? Here. Dr. Mahmood?
Yes.
Dr. Thorpe?
Here. The first order on the agenda is the election of a vice chair. The chair would consider nominations for vice chair.
I'll nominate Dr. Helzer.
Are there other nominations? Okay, Dr. Helser's been nominated and second. Is there any other discussion? Seeing none, all those in favor? Oh, well, I guess we need to call the roll.
Mr. Brooks? Dr. Hilzer?
Abstain?
Ms. Lawson?
Aye.
Dr. Mahmood?
Yes.
Dr. Thorpe?
Aye.
Motion carries.
Thank you.
The next item on our agenda is the oral argument on the non-adopted proposed decision on Dr. Edward Paget. And I will turn the proceeding over to our honorable judge. I'll trade you places.
Good morning. My name is Heather Rowan. I'm here to proceed over this non-adopt portion of the hearing this morning. So we will go on the record. We are on the record in the matter of the Medical Board of California and the matter of the accusation against Edward Thurston Paget, OAH number 2021030452. This is the date, time, and place set for hearing in the notice of hearing for oral argument. My name is Heather Rowan. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to preside over this hearing. Prior to going on the record this morning, the panel B established there is a quorum. May I take the appearance of counsel for I'm sorry, I'm going to start with the Deputy Attorney General. Are you on the line?
Hello, I'm on the line. I'm Deputy Attorney General Robert Lincoln here on behalf of complainant.
Good morning. And for respondent?
Yes, good morning. My name is Paul Chan, and I represent the respondent, Dr. Edward Paget.
Thank you. And Deputy Attorney General, could you spell your last name, please?
Yes, Lincoln, Lincoln.
Thank
as in
you.
the president.
Got it. Thank you. I'm going to briefly go over the ground rules for the brief hearing today. The board has issued an order of non-adoption of a proposed decision by an administrative law judge. The board today has invited discussion over whether the proposed order should be modified. The following process and time limitations will apply. I will give respondent 15 minutes to make an opening argument. I will give the Deputy Attorney General 15 minutes for a response, and each of you 5 minutes for closing. I will have a timer. I'll let you know when you have 2 minutes and 1 minute left. I will strictly enforce the time limits. The arguments will be based only on the existing record and not exceed the scope of the record of admitted evidence. No new evidence will be heard today. The panel members may ask questions of the parties to clarify the arguments, but may not elicit new evidence. Following the argument today, the board will go into closed session to deliberate. The parties will not receive a decision today, but will sometime in the future. We will begin with Dr. Paget's argument. And for the record, Dr. Paget is not present today. He is represented by Mr. Chan. Mr. Chan, you have 15 minutes.
Great, thank you. Good morning, members of the board. Good morning, Your Honor. Hopefully, each of you have an opportunity to have reviewed the written arguments submitted on behalf of both parties. So rather than sort of rehash the procedural history or some of the facts, I want to just simply address one of the issues that the board wanted the parties to address, whether or not the level of discipline ordered is sufficient to protect the public. Well, in this case, after a 2-day hearing, the administrative law judge's proposed decision was that no discipline should be imposed. The accusation filed against Dr. Paget should be dismissed. Now, I am asking that this board reconsider the rejection and adopt the decision, come to the same conclusion as the administrative law judge, which is to dismiss the accusation filed against Dr. Paget. I'm not making this request based on any type of arguments. I'm asking that the board simply do exactly what the administrative law judge did in this case, which is render a decision guided only by the facts, only by the evidence. The facts and the evidence of this case can only lead to one conclusion, and it does not lead to the conclusion that any discipline needs to be imposed. My client didn't do anything wrong. His conduct does not arise to any level of discipline. Imposing discipline simply on the basis of some concern not supported by the evidence is punitive. As stated from the arguments, as indicated by the records and the evidence of this case, my client has been a licensed physician since 1969. Since 1969, he has practiced medicine without issue, without complaints, without any history of discipline. And the issue in this case, what happened in October of 2019, while he was performing general surgery, that issue has been resolved. My client submitted to 2 evaluations, one of which was a psychiatric evaluation, despite the fact that the initial complaint had nothing to do with his mental capacity. But my client complied, which is why the report on the psychiatric report indicated, I'm not even sure why I'm evaluating Dr. Paget. There's no issues. Then the second evaluation conducted by Dr. Brown, the report and his testimony, which is part of the record, Dr. Brown made it very clear. Made it clear in his report and made it clear during the hearing that nothing further is required of Dr. Paget. And at the time, the only caveat was that Dr. Brown said, if respondent complied for 1 year. That was May 2020. And all of the evidence indicated and proved that my client complied with all the conditions, and there's been no further incidents. So complainant request is for probation of 5 years. They're requesting a term of probation of 5 years to put my client, an individual who's been practicing since 1969, now to mar his record. For what? Because my client is of an advanced age? Without evidence, why are we putting Dr. Paget, or even that's even being considered, of placing him on probation? So that he can be watched? By whom? Is there any evidence that his competency or his clinical skills are at issue? Is there any evidence that any member of the public or his patients has been harmed in any way? The answer is no. The request for a 5-year probation is not supported by the records. It's not supported by facts. It's not supported by the evidence. It is motivated by some speculation that somehow Dr. Paget is such a danger to the public that 5 years probation needs to be imposed on him. I'm asking members of this board to review the evidence, which I hope you will, look at the arguments, and be guided only by the facts, only by the evidence. The record is, in my arguments, I've addressed very specific facts. Obviously, any members of the board have any questions, I'm happy to answer or clarify. But my request is that the proposed decision be adopted and that no level of discipline be ordered against Dr. Paget. Thank you very much.
Thank you, Mr. Chan. We will go to Mr. Lincoln. Mr. Lincoln, give me 1 second to reset the timer. Just to confirm, you're still with us, yes, sir?
I am.
Okay. You have 15 minutes.
Good morning, Your Honor, and members of the board. Thank you for having me today and listening to my arguments in this matter. This is a case involving a physician who is impacted by physical ailments that affect his ability to practice medicine safely. On October 4th, 2019, the board received a complaint that respondent had fainted while performing gallbladder surgery on a patient. On May 22nd, 2020, respondent voluntarily submitted to a physical evaluation from board-appointed physician Dr. Hosea Brown III. Dr. Brown concluded that respondent had experienced multiple episodes of syncope, specifically that respondent's symptoms of dizziness and near syncope upon prolonged standing while operating are consistent with possible hypoglycemia and hypertension. Dr. Brown concluded respondent should not perform any surgical procedures in the capacity of a primary principal surgeon, which would require prolonged standing for 3 hours or more, that it would be prudent for respondent to function as an assistant surgeon to maximize the care of the patients and minimize the possibility of any medical condition occurring. Finally, the respondent's degenerative knee disease compromises his ability to stand for long periods during surgery. Given these facts, if the board were to adopt the extremely lenient position of dismissal of the accusation and not place any conditions upon respondent's license, it would be contrary to the board's disciplinary guidelines and contrary to the board's interest on protection of the public and respondent's rehabilitation. The evidence before you does establish respondent's ability to practice medicine safely is impaired because he's physically ill, affecting his competency. Respondent's non-cardiac syncope due to medications and his degenerative knee disease contribute to his fainting spells and, when not monitored properly, impair his ability to practice medicine safely. These are the conclusions of Dr. Brown. We need more than just respondent's word that he's going to monitor his own health closely. We need to place conditions on his license in order to ensure protection of the public. The ALJ incorrectly concluded that respondent's fainting episodes, age, degenerative knee injury, and non-cardiac syncope due to medications were not physical ailments impairing respondent's ability to safely practice medicine. It is clear if respondent's health is not monitored properly, he can present a harm to public safety, as he did on the day of October 7th, 2019, when he fainted during surgery, and the patient remained under general anesthesia for a period of time until the respondent was resurrected. resuscitated. The ALJ incorrectly gave too much weight to respondent's offer of evidence that since the October 7th incident, he has made lifestyle modifications and rarely performed surgeries that exceed 2.5 hours. While his modifications are laudable, the board's main goal is public safety, and merely taking his word for these modifications is not sufficient to protect the public. Respondent's license must be placed on 5 years probation with restrictions in order to give the board opportunity to monitor licensee's health and ensure public safety. Imposition of a probationary period and restrictions are required in this case to protect the public. The board's disciplinary guidelines are intended to promote uniformity and deterrence. The sole cause of discipline in this matter is a physical or mental illness affecting competency. If the board determines respondent is unable to practice medicine, you can take the following actions: revoking his certificate or license, suspend the right to practice, place the license on probation, or take any other actions that you, within your discretion, deem proper. Given Dr. Brown's expert report and testimony at hearing, the board should find that respondent's physical condition requires imposition of conditions to practice safely. The appropriate conditions are minimum stayed revocation 5 years, undergo medical evaluation and treatment, prohibit practice, do not perform surgeries longer than 3 hours, perform surgery in the capacity as an assistant surgeon only. For these reasons, the board must impose discipline upon respondent's license to ensure his rehabilitation and public protection. Thank you.
Thank you, Mr. Lincoln. Mr. Chan, you have 5 minutes in close.
Yes, briefly, complainant's request for discipline of probation of 5 years, they're simply recycling arguments that they made during the hearing, which was rejected by the administrative law judge. Their premise is because of what happened in October of 2019, discipline of 5 years probation must be imposed in May of 2022. So let's remind the complainant, and perhaps it would be help refresh the memory of this board, what Dr. Brown actually wrote in his report. Dr. Brown was an independent witness. Dr. Brown concluded that respondents' continued practice of medicine does not pose a present danger or threat to the public health, welfare, or society at this time. Dr. Brown also concluded, it is my medical opinion that any restrictions or modifications of the physician's status pertinent to his license to practice medicine in California are not warranted at this time. This is the complainant's witness at the hearing. This is not Dr. Paget's physician testifying. This is the individual that Dr. Paget was asked to be evaluated by. So somehow, complainant wants us to disregard those two pertinent conclusions by Dr. Brown and still impose a probation of 5 years. That somehow Dr. Paget is dangerous and he needs to be monitored. The evidence demonstrated without impeachment or rebuttal during the hearing that between October 2019 to the date of the hearing, Dr. Paget successfully completed over 100 surgeries without issues, without any issues to himself or the patients. So now what the complainant asks is, in 2022 of May, we need to do this stuff because, we don't know what's going to happen. This sets an extremely dangerous precedent for this board. What's next? Are we going to start requiring physicians to under annual physicals? Make sure everyone's taking care of their health? Making sure that, no future issues happen because someone is of an advanced age is ludicrous. It's not backed up by the evidence. Follow the evidence and the facts of this case. What they're asking for is punitive. No discipline should be imposed. Thank you.
Thank you, Mr. Chan. Mr. Lincoln, you have 5 minutes in close.
Thank you. Our basis for the 5-year requirement is additional to Dr. Paget's own testimony that he intended to retire and step back from his practice. So given his physical ailments and the fact that Dr. Paget is one of two surgeons in Needles, California, heightens the need for public protection. The 5-year term is appropriate. The board cannot rely on Dr. Paget's statements that he will modify and step back and eventually retire in 5 years. The 5-year time period allows the board to monitor respondent, his health, his ability to practice, and protect the public. Thank you.
Thank you, Mr. Lincoln. I will turn it over to the board for questions of the parties. So we'll start with Dr. Thorpe.
Thank you, Judge. I apologize for my voice. So I think what the panel was concerned about was not that Dr. Paget had committed some error that we had found out during the hearing. The question was agreed because of his advanced age and several medical problems that were listed, diabetes and coronary disease. Was it appropriate to just ignore this incident? So my question, I think you answered it, Mr. Chan. I have a question for Mr. Chan and a question for Mr. Lincoln. Mr. Chan, there was a statement made in the record that Dr. Paget was going to cut back on his procedures and going to limit them to less than 3 hours. I don't know if this is new information, and I don't mean to introduce this, but I think the question is pertinent. Has he done that since his hearing in 2020?
So I want to caution you to limit your answer so that
Per
we're
the-
not introducing new evidence.
Per the records, Dr. Thorpe, to address your question in two-part, Dr. Paget testified and also introduced records of a recent medical examination that he has taken the appropriate steps of, first of all, addressing the health issue, the medication management, and the fact that they brought in a stool for him to sit on. He also testified during the hearing that since the incident itself, the majority of the procedures, I think almost all of them, was less than 3 hours. But more importantly, they were in the process of hiring a new general surgeon that he was in the process of training.
Okay.
And per the record, once again, it's not a matter of saying, oh, we just take his word for it. The man testified without being impeached or rebutted by any evidence from the complainant. He also testified at the time of the hearing that in addition to scaling back the number of surgeries he was performing, hiring a new surgeon, he was in the process of retired. As of today, he remains retired. And retired means not from the practice of medicine, but being a general surgeon. He's now a medical director, as indicated in the records.
Mr. Chan. The evidence at hearing is what we're
Okay,
looking for. I know that Dr. Thorpe
thank you.
is looking for more current information. And you had a question for Mr. Lincoln?
For Mr. Lincoln, so even though your expert states that there should not be any restrictions or modifications to his license to practice, I guess I'm questioning, why are you disregarding that evidence and asking for a longer or the same, going back to the same request for probation for 5 years?
Mr. Lincoln,
So
okay.
your question is, why are we disregarding those health issues in our basis?
No, I'm asking you, your expert states that in his medical opinion, the conditions that were concerning are not a reason to limit his practice. Why are you going back and basically requesting the same discipline that was denied at the administrative law judge hearing?
Oh, yes. So the basis, the strongest basis is the fact that there's only one of two surgeons out in needles, and given the health profile and the age of respondent, we believe it's appropriate to monitor him as he winds down his practice for 5 years.
Thank you.
Mr. Brooks, do you have questions?
I do not, but I'm going to probably recuse myself from this if it's okay when we have the votes. We have a quorum without my vote because I did miss the first 5 minutes of this. I don't want to bias.
Okay, thank you. Down the line, I think it's Dr. Hilzer. Is that right? Okay.
Thank you, Your Honor. Mr. Chan, I did read the statements from Dr. Brown in the transcript, and in addition to the statements you cited, he also said that Dr. Paget needs to use wisdom with respect to his future practice of surgery. What are your comments on that?
Well, I think all physicians should exercise some level of good judgment and wisdom in all levels of the practice. But within the context of Dr. Brown's statements, that was also in the context of additional recommendations he's made regarding Dr. Paget, what he needed to do. And he specifically mentioned that some of the changes that he was suggesting to Dr. Paget, that he followed him for a period of 1 year. And that was a point of contention, and not a contention, a significant fact during the hearing, because the 1 year time period was from the time he evaluated Dr. Paget and issued the report on May 22nd, 2020, which would have brought us to May 22nd of 2021. And at the time of the hearing, Dr. Paget had exceeded that 1 year time period without issue, following the precise recommendations of Dr. Brown.
Thank you. I have a follow-up question on your comment about Dr. Paget's retirement. And Your Honor, please tell me if this is not a permissible question. Does Dr. Paget still have privileges as a primary surgeon?
Okay, so I'm going to interrupt here because the evidence before the board was what was presented at hearing, what was
Yeah.
before the administrative
I'll
law
limit it to
judge.
what was presented at the hearing.
Okay.
Yeah, at what was presented at the hearing was he did
He did.
retain
Thank
his privileges. He was assisting and in the process of training. That was if you want the specific sites, I probably have it here somewhere, but that's what he specifically testified to during the hearing.
Okay, thank you. I have no further questions. Thank you.
Thank you.
Thank you. And Miss, I know it's JD, Lawson. Yeah, no question. Okay. Dr. Mahmood.
Thank you. Approximately how many procedures he has performed of any duration after this procedure until you have the knowledge?
Your specific question, how many procedures he performed between
After that
October?
episode and until whatever the time you have the information.
Yes, I have it on the record. I believe it's 117.
After that procedure.
Correct, from October 2019 to the date of the hearing
Okay.
on February 1st. No, at the hearing on November 30th, 2021 and December 31, I believe we submitted the log, and I believe it was calculated at 117 numbers, 117 procedures.
Okay, that's fine. Exact. So is this about the same routine? He has done the surgeries in the past number
Same.
of cases? Is it the usual number of cases he performed in last 5-10 years, whatever he's been doing, or it's gone down?
I don't recall if that was ever addressed during the hearing as far as how many. I think he gave a general testimony during his direct examination that, given his years of practice, the type of procedure he performed, I think it was in the thousands.
Okay. Okay. Any issue with any of the procedures after that?
None,
None.
none.
Okay.
And I believe the record actually cited Dr. Mahmood, that Dr. Brown thought it was remarkable that Dr. Paget had never even been subjected to a medical malpractice claim.
Has he had any issue going to the hospital or having any suffering, any other medical issue during this time, significant medical issue?
not since the singular issue that was the subject of the whistleblower complaint that occurred on October 7th of 2019.
Okay. I have a question for the other
Mr.
side.
Lincoln?
Yes. Mr. Lincoln, you're asking for a long probation in this case, based on, they mention about multiple cases, but what we see, there's only one significant case. And he's been cleared to practice by his psychiatrist, whatever we requested, and medical doctors. Is it appropriate to just ask the full probation or just have some concern on prolonged procedures like longer than 3 hours?
Are you asking, is it full right to ask for the full probationary term
Yeah,
and not just have conditions
yes,
such as longer for 3 hours?
yes. Or
Well,
2 hours, I mean, it's not.
please.
Mhm.
Yes. So my argument is for the 5 years and for the conditions, and you as a board member and the board are empowered to determine the appropriate level of punishment given the facts and the record and our arguments.
Okay, I have no more
But
question.
as I
Thank you.
stated, yeah, thank you.
Thank you.
Thank you. Anything further from the board members? Okay, this concludes the oral argument. At this point, the record is closed. The matter is submitted. We are off the record. I will turn it to Dr. Thorpe to bring us into closed session if that is next on your agenda.
Thank you, Judge. So at this point, the hearing will be moved to closed session to deliberate on this case. This is Richard Thorpe. We're calling the open session for panel B back to order. We've completed our business, so a motion would be in order to adjourn. It's been moved and seconded to adjourn. I don't think we need a vote. Thank you very much for your participation today.